And I would say to you all tonight that if you went to Epping and went to Hampton, they will categorically stand up and say that their towns are the envy of every single town in New Hampshire in terms of providing opportunities. Their kids are close by, whether it's schools, little kids playing little nippers, and so on and so forth. So,
this is a summary of a 28-page correspondence in 3 minutes from the law firm of Murray, Plum, and Murray, representing Freeport Save Our Neighborhoods Coalition, and makes the following points about Coastal Soccer Club's proposed zoning amendment. First, that it radically departs from the pattern and the reasoning by which the zoning ordinance currently allows commercial indoor recreation in only 6 out of the town's 20 major zoning districts, not counting the shoreland zones, which also exclude commercial indoor recreation. Commercial indoor recreation is not even allowed in some of the town's growth districts. It would be wildly inconsistent with the current zoning scheme to permit commercial indoor recreation in the RR1 zone. Second, that the proposed recreation district is in effect nothing more than an attempt to engage in contract zoning with Coastal Soccer Club concerning a single project without observing any of the legal requirements for contract zoning, and in a zoning district where the ordinance specifically forbids the use of contract zoning. Third, that to rezone part of the RR1 zone to allow commercial indoor recreation would be inconsistent and out of harmony with the comprehensive plan the town adopted just last year. The plan does not purport to tolerate the rezoning of small parcels without an appropriate amendment to the plan itself. More importantly, it contemplates that commercial development opportunities will be expanded only within the existing commercial zoning districts, rather than allowing development to spread to other districts where it is not currently allowed. The rural zones are intended to be a repository of open land where the only permissible type of commercial recreation is outdoor recreation. The plan does not recommend any increase in commercial indoor recreation anywhere within the town. Indeed, the word indoor appears nowhere in the plan. Fourth, the proposed rezoning violates Section 2.12 of the Town Charter, which forbids the council from establishing any growth areas within the West Freeport Village area. The point is not whether the council formally calls the rezoned area a growth area. The obvious purpose of Section 2.12 is to prevent the council from allowing within the West Freeport Village any types of development that are allowed only in growth areas. Fifth, the proposed recreational district does represent illegal spot zoning. It rezones a small area for the specific benefit of Coastal Soccer's proposed soccer dome in a manner that is inconsistent with the town's comprehensive plan. Whether a proposed development benefits the public, particularly when it benefits only a small fraction of the public, does not make spot zoning legal. Sixth, even if all the problems previously mentioned did not exist, the language of the zoning amendment is itself contradictory, illogical, and inadequate to preserve the rural values that are highlighted repeatedly throughout the comprehensive plan. Among other things, the amendment exempts commercial indoor and outdoor recreation from site plan review that is required of every such use in every other zoning district. The amendment also requires none of the buffering that is ordinarily required by the ordinance when a commercial zone abuts the RR1 zone. 2 more sentences. Finally, if the council grants Coastal Soccer Club's rezoning proposal, it will be virtually impossible for it to turn down any future request to rezone parts of the RR1 zone to allow commercial indoor recreation or any other use that is not permitted in the RR1 zone. Word gets around. If the council grants Coastal Soccer Club special favors, you can expect other commercial operations to line up asking for similar assistance.
Again, my name is Rob Crawford. I appreciate the chance to be here tonight. We received the communication last night. I was in Cape Elizabeth about this time, so I got this a little bit later this morning. I've had a chance to review it, and classic to attorneys, as pointed out by Councilor Bishop. We don't adopt fully Mr. Bannon's opinions as advanced. The first thing I wanted to talk about sort of generally is just this concept of a comprehensive plan and what it is. And the courts have had a chance recently to construe some disputes related to a comprehensive plan, and somewhere in my magic file in here, I actually brought a case. The case relates to the Nestles Water. Many of you know them as Poland Springs. And there were some issues there as to whether or not the ordinances were consistent with a comprehensive plan. And in trying to sort this out, the court made, I think, some very good announcements about what really comprehensive plans are. Because if you pick up and you look at the Freeport Comprehensive Plan, it is a guide. It is like a mega trend. It is like trying to announce some broad policies to consider and to advance as a vision for the town. In fact, if you look at the beginning part of this, there's a lot of verbiage there talking about a strategy to achieve the vision. And then within it, certainly, if you look at the structure, it doesn't state every particular precise component related to every single district in the town. It's up to somebody looking at this to say, is what's being advanced here fairly within the scope of what was reasonably expected, what was reasonably known at that time. It's not a static document either. A comprehensive plan is a mission. It's like, let's get going with this. And the adoption of a new comprehensive plan doesn't wipe out all your old ordinances and say we're starting afresh. What it says is this is how we're going to try to modify what we have now and get to the points in the mission. And so something can come along where it's time for you to stop and reflect and say, now what's being advanced here? Is this in line with the mission of what we're trying to accomplish in the town? I also took a look at your charter, and I know we sent a letter out on this a couple weeks back about this issue about the growth areas. And I think it's important from a lawyer's perspective when we look at that provision in your charter. It was obviously put there, and it was put there in a precise way. When a lawyer reads that and sees the term growth area that's in capitals, they say, what does this mean? Because that's part of what's known as the growth management statutes. And a growth area is very specifically defined in statutes. And it's not just this sort of broad idea of some things that some certain particular things can happen, in my view. A growth area, as defined by statute, means an area that is designated in a municipality's or multi-municipal region's comprehensive plan as suitable for orderly residential, commercial, or industrial development, or any combinations of these types of development, and into which most development projected over 10 years is directed. That's a growth area. So I think the points that raised here, I look at your charter, I look at this language, and to me, that's what the prohibition or the restriction is on your council's power in terms of a growth area in the West Freeport district. Okay, so we have that sort of set the stage on those points there. Now, when we look at the comprehensive plan, again, the court talks about a comprehensive plan as being a guidepost, as being something that sets the broad parameters, and it's the ordinances that are adopted by you as the legislative body of the town that are trying to advance the vision. So it's within your purview and your consideration as to this request, whether it advances the broad vision of the comprehensive plan and it's consistent within it. So then I took a look at your comprehensive plan, and while it doesn't talk about indoor commercial recreation facilities in any detail, there is, as I pointed out in my earlier letter, a discussion in here about open space and recreation. And it doesn't separately discuss those. It talks about them in concert. And there's a specific provision at page 9 that I referred to in my letter that I think gives you an opportunity as the persons who are making the decision as to whether or not this is consistent with the vision to make an informed judgment as to whether or not recreation is something that was embodied in this concept, and whether or not this type of recreation, which I think is an adjunct to the outdoor recreation, is consistent with this vision. So I find within the four corners of this document the discretion available to you to make an informed decision as to whether or not this proposal fits within the comprehensive plan. Your view is what's important here. Does this direct that indoor recreation that's done in concert with the partnership with the town is something that you couldn't have as a result of the comprehensive plan. That's up to you to decide, but I think within the four corners of this, you could make the decision that no, that in fact, it's something that can be accommodated here and used. But that's, again, that's my opinion. The next thing I wanted to talk about, and a little bit with the points that were advanced by Mr. Bannon, is that a lot of this, by comparing whether or not this is allowed in the many districts in the town or not, to me, that's just sort of a red herring argument. The fact is, you make the decision based on the confines of the comprehensive plan and what you think the vision is here and what the opportunities are, and make an informed judgment whether you want to advance this proposal or not. I did note in my letter of some weeks past, too, that there was much discussion here tonight that there aren't commercial activities that are allowed in residential zones. There are some commercial activities that are allowed in residential zones. Again, it's something that was informed at the time, an accommodation to kind of get an idea, primarily residential, but you can have commercial outdoor recreation facilities, nursing homes, campgrounds, daycare facilities, bed and breakfast, inns. Those are all commercial activities that are allowed in a primarily residential district. So is this concept, again, so you have to decide, consistent with that concept in advancing it. I also note, too, that what's really being advanced here is not commercial, residential, indoor facilities. What's being advanced here is a new provision, a new zone that has different definitions in it. If I can flip to them here. It has two types of permitted uses that are allowed: outdoor recreation, including, with all the lists of the types of activities there, and indoor recreation use, which is a primary use in a structure for uses, same types of activities. And then there's an express exclusion in here that the limitations on indoor commercial recreation otherwise in the ordinance don't apply to this zone. One of the points that Mr. Bannon made, too, is about spot zoning. Spot zoning is always getting a bad name, right? But in fact, the courts have suggested, as I reported in my letter, that if there's a need for this facility and it's reasonably consistent with the needs of the community, some allowances are granted to communities who advance these types of zonings. There's criticism in Mr. Bannon's document here that what's being advanced isn't particularly precise in all ways, and I think there were some points raised tonight that if you advance this ordinance just like this and passed it, it could be that this could take place in any residential zone throughout the community. But that's one of the reasons that, and I shared this with Donna, that the process that we recommended is that if you want to advance this, is send it to the planning board, because the planning board is your trusted body here that's informed, makes planning decisions all the time, has the benefit of Donna's skill set and other folks that can do that, to fine-tune this, to really understand what the impacts would be if and when that ordinance was advanced. Let me see some other points that I have here. There's provisions in here that suggest that this is somehow that the town is, by signing the purchase and sale agreement, has committed itself to delivering a zoning change. I take umbrage with that. First of all, the purchase and sale agreement was signed by the legislative of the body that predates this legislative. There was an election somewhere in there. And there's a concept that's well embedded in law that a former legislative body can't bind by contract the actions of this legislative body. So this purchase and sale agreement, in my view, doesn't promise a delivery of any zoning. It promises nothing more than you will cooperate in this joint effort with the developer to seek the zoning and have the fair opportunity to seek that zoning. So it's only, you can't deliver it. You can't promise it by contract. I tell you can't. I don't read this contract as doing that. The buyer has to get the permits and the changes to make this go. That said, typical of most types of these transactions like this, there's provisions in here that the purpose of the purchase would be frustrated, and in fact, they couldn't actually go forward with this. And so those clauses that John Bannon has identified in here, to me, are reasonable commercial contracts, and they don't tie your hands. There's a provision in here, or argument that's made in here, about this being inconsistent with the comprehensive plan. I think I've covered my thoughts on that. There's a provision in here that says this violates the town charter. I think I've covered that point, that this represents illegal spot zoning. Recall that for this type of zoning to be illegal spot zoning, it would have to also be inconsistent with the comprehensive plan. And that's something that you get to decide one way or another. And I think there's grounds within the comprehensive plan that you could conclude that, in fact, what is being proposed here is consistent with the comprehensive plan. There's another argument made in here that the consequence of the purchase and sale agreement steering and you delivering the zoning would therefore constitute contract zoning. I don't see that. I don't see that as a consequence, because in my view, the purchase and sale agreement doesn't obligate you to deliver zoning. It just obligates you to cooperate with the developer on this joint effort in securing whatever permits they are entitled or are trying to proceed and obtain. The last thing, Donna and I did talk a little bit about the language of the proposed amendments and the argument here that they're flawed. Again, I think this is a process in motion. There's some things that have been raised here, classic to zoning and land use. You want to understand the impacts well before you issue the edict and adopt a change in zoning, so you really understand what's being defined, what the options are, and what the mischief could be if the decision isn't well thought out. Make sense? Okay.
Just a question for the attorney. Are there any consequences to the town financially if we do not approve the zoning change?
Are there any?
From the purchase and sale agreement, you just talked about how
Yes.
there really isn't any obligation for us to be the sponsors of the zoning change or to actually make the zoning change happen, even though we're party to the purchase and sale. My question is, are there any consequences? It's a broader question.
Well, in my view, I think I've summarized what I think the purchase and sale agreement is there, and I don't have in front of me the actual purchase and sale agreement. I might have left it over there, but there are some cost-sharing provisions in there related to money that was agreed to be advanced for the effort. And I do not recall if there's any other how the distribution of the deposit or anything would be made if all the necessary approvals are not obtained by the developer.
Original order as written in the second stand. So is our council's ready to vote on that motion?
Yes.
Yes. Okay, Council Arno?
Yes.
Council Bishop?
No.
Council Gideon?
Yes.
Councilor Hendricks?
Yes.
Councilor DeGrand Prix?
No.
Councilor Egan?
No.
Yes.
Sorry.
Yes.
Chair votes yes. Could we have a motion to adjourn, please?